discussion on criminal procedures. We are already done with the basic concepts of the criminal procedure, such as we already finished discussing yung concept, okay, yung interpretation, the due process, and some of the jurisdiction. So, a short recap of the previous discussion. The concept of criminal procedure, okay? To refresh your mind, criminal procedure treats of the series of processes by which the criminal laws are enforced and by which the state prosecutes the person who violate the penal laws. In the clear language of the court, criminal procedure regulates the steps by which one who committed a crime is to be punished. This is stated in the case of People versus Lacson. Okay? As to Black's Law Dictionary, criminal procedure is described or defined as: criminal procedure is a generic term to describe the network of laws and rules in which governs the procedural administration of justice. Always remember, the system of procedure in our jurisdiction is accusatorial or adversarial. Okay? As provided in the case of Keto versus Catolico. What do we mean? Anong ibig sabihin pag accusatorial or adversarial? Galing sa salitang adverse, okay? Adversarial, accusatorial. Okay? Pareho lang 'yan. When we say accusatorial or adversarial, it contemplates two contending parties before the court which hear them impartially and renders judgment only after trial. Ibig sabihin, meron pong dalawang magkalaban na partido. Kasi nga adverse, diba? Adversarial. Before the court can be a municipal trial court, regional trial court, court of appeal, Supreme Court, okay, which hears them impartially, okay, ibig sabihin hindi bias, okay, and renders judgment only after trial. Sa isang accusatorial or adversarial system, the system has two-sided structure consisting of the prosecution and the defense. Okay? So, ibig sabihin, meron po tayong prosecution, ito yung nagkakaso, at saka yung defense. Okay? Where each side tries to convince the court that its position is the correct version of truth. So, anong pinagkaiba ng adversarial sa isang inquisitorial? From the word inquisitorial. Okay? Here, adversarial system should be distinguished from inquisitorial system, kung saan yung korte plays a very active role and is not limited to the evidence presented before it. Sa isang inquisitorial system, napaka-active po ng korte natin. Ang korte sa isang inquisitorial system, hindi lang siya, okay, limited sa evidence na pine-present ng mga parties. Okay? Yung korte, the court may utilize evidence. Okay? Pwede siyang mag-gather, pwede siyang gumamit ng mga evidence outside the court, and a judge or group of judges under this system actively participates in the gathering of facts and evidence instead of merely receiving information or evidence from the parties. Okay? We go with the liberal interpretation. Anong ibig sabihin ng liberal interpretation? Ang ibig sabihin ng liberal, hindi stricto. Free, kumbaga. Hindi stricto. The rules on criminal procedure being part of the rules of court, okay, shall be liberally construed. So, pag tinanong kayo sa board exam nyo, okay, how is the rules in the criminal procedure interpreted? Ang sagot nyo dun is liberal. Okay? Liberal construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. Okay? This is provided in your section 6, rule 1 of the rules of court. So, how about due process? Ano naman ang due process? I know that you know this one. Okay? Due process in criminal proceedings is mandatory and indispensable and cannot be met without proverbial law which hears before it condemns and proceeds upon inquiry and renders judgment only after trial. Sa case ng Alionte versus Savellano Jr., okay, sabi ng Supreme Court, meron tayong requirements, okay, for due process sa isang criminal proceeding. Ilan? 4 lang. Okay? Criminal proceedings, there are 4 requisites in order to meet due process. Ano yung 4 na ito? Number 1, meron korte or tribunal that the court or tribunal trying the case is properly clothed with judicial power to hear and determine the matter before it. Okay? Number 2, the jurisdiction is lawfully acquired by it over the person of the accused. Number 3, that the accused is given opportunity to be heard. Okay? And number 4, the judgment is rendered only upon lawful hearing. Okay? So, we go with the requisites for the exercise of criminal jurisdiction. Okay? Ano yung mga requisites for the exercise of criminal jurisdiction? There are 3. Okay? In the case of Cruz versus Court of Appeals, okay, the following are the basic requisites before a court can acquire jurisdiction over a criminal case. Itong 3 daw ito ay mga requirement para magkaroon ang korte ng jurisdiction sa isang criminal na kaso. Ano yun? Okay, number 1, jurisdiction over the subject matter. Number 2, jurisdiction over the territory. And number 3, jurisdiction over the person of the accused. Of course, okay, we already discussed this when last meeting. Okay? We go with of course, you remember your principle of adherence of jurisdiction or continuing jurisdiction. Okay? Para ma-refresh ko na lang din yung mind or your memories about the 3 jurisdictions, yung subject matter, territory, at the person, I will discuss na lang din. Okay? We go first with jurisdiction over subject matter versus jurisdiction over the person of the accused. As regard to jurisdiction over the subject matter, okay, it refers to the authority of the court to hear and determine a particular criminal case. Okay? Whereas in a jurisdiction over the person of the accused, it refers to the authority ng court. Siyempre, not over the subject matter of the criminal litigation, but over the person charged. Okay? Sa jurisdiction na ito, it requires that the person charged with the offense, okay, yung kinakasuhan, ng criminal case or ng offense must have been brought in its forum sa korte, okay, for trial, forcibly by warrant of arrest or upon his voluntary submission. Paano naman yung jurisdiction over the territory? Can you waive this? The answer there is no. Okay? Ang jurisdiction over the person, can you waive that? Yes. Okay? Pero yung jurisdiction over the territory, can you waive that? The answer there is no. Okay? This element requires that the offense must have been committed within the court's territorial jurisdiction. This fact, okay, is to be determined by the facts alleged in the complaint or information as regards the place where the offense charge was committed. Okay? Venue in criminal cases is an essential element of jurisdiction. So, ibig sabihin nito, for jurisdiction to be acquired ng korte natin sa isang criminal case, yung criminal act o yung offense dapat ay committed or isa sa elements nito or yung ingredients ng crime should have taken place within the territorial jurisdiction of the court. Remember also that there are offenses or criminal acts, okay, that a court has still jurisdiction to try even if such are not committed within its territorial jurisdiction. You read your Article 2 of your revised penal code. Okay. We go now to the prosecution of offenses as provided in your Rule 110. Okay? Institution of criminal actions. Ano nga ba ang purpose ng isang criminal action? The purpose of a criminal action is to determine yung penal liability of the accused for having outraged the state with his crime, and if he be found guilty, to punish him for it. So in this sense, okay, yung parties to the action are the people of the Philippines and yung accused. So if you could remember your cases, okay? 'Di ba pag may mga binabasahan ng kaso during arraignment, ba? Ang maririnig ninyo is people of the Philippines versus Pedro Cruz for the crime of estafa. GR number 123456. Example. Okay? So here, anong mangyayari? Yung niloko ni Pedro, the offended or yung victim. Okay? The offended party is regarded as merely as the witness for the state. Next is how criminal actions are instituted. Paano po ba mag-file ng kaso? Okay? The institution of a criminal action generally depends whether or not the offense is one which requires a preliminary investigation. So, una daw, sa sasampa ng kaso, okay, dapat ma-determine muna kung kailangan ba ng preliminary investigation or hindi. Okay? Kung kailangan ng preliminary investigation, a criminal action is instituted by filing the complaint with the proper officer. for the purpose of conducting the requisite preliminary investigation. So, ibig sabihin nito, kung kailangan daw ng preliminary investigation, magfa-file ka ng complaint sa proper officer. Bakit? Okay, bakit ma'am? Kasi itong officer na ito will conduct a preliminary investigation. Number 2, paano naman ma'am kung hindi kailangan ng PI or yung preliminary investigation? Okay? There are 2 ways to file or institute an action. Okay? The first is by filing a complaint or information directly with municipal trial court, okay, or the municipal circuit trial courts. And number 2 is by filing a complaint with the office of the prosecutor. Okay? Remember that kung ang actions, yung criminal actions, okay, is located in Manila, okay? In Manila and other chartered cities, a special rule prevails, okay? In these places, the rule is that the complaint shall be filed with the office of the prosecutor, okay? Unless otherwise provided in their charters. Ma'am, pwede ka bang mag-file directly sa RTC? Okay. The answer there is no direct filing of an information or complaint with the RTC under Rule 110 or 110. Bakit? Because ang jurisdiction, okay, its jurisdiction yung RTC. It only covers offenses which require preliminary investigation. Ma'am, paano ba namin malalaman kung yung action is required ng PI o hindi? Simple lang. Okay? Memorize nyo yung number na 4, 2, at 1. Ano yung 4, 2, 1 rule? Okay? A preliminary investigation is to be conducted for offenses where yung penalty prescribed by law is at least 4 years, 2 months, and 1 day. Okay, that is the rule 421. Kung yung offense ay may penalty na at least 421, 4 years, 2 months, and 1 day, that will require a PI. That is provided in your Section 1, Rule 112 of the Rules of Court. Okay? So, ang regional trial court po natin has jurisdiction over offense punishable with imprisonment of more than 6 years, a period way above the minimum penalty for an offense that requires preliminary investigation. Pero, okay, sa kabaliktaran naman tayo, ang isang municipal trial court, meron siyang exclusive jurisdiction over offenses punishable with imprisonment not exceeding 6 years. Okay? Next one. As regards to effect of the institution of the criminal action on the prescriptive period. Ano daw po ang effect ng pag-file ng action during the prescriptive period? Anong ibig sabihin nito? Okay? The present rule provides that institution of criminal action shall interrupt, magi-stop, okay? Iistorbohin niya daw yung period of prescription of the offense charge unless otherwise provided in special laws. Okay? So, for offenses where preliminary investigation is not required, the filing of information or complaint directly with MTC, okay, or with the prosecutor shall likewise interrupt the filing of prescription. Okay? Example, bigyan ko kayo ng example. Sa case ni People versus Bautista, GR number 168641, April 27, 2007. Okay? Here, it involves a case of physical injuries. Okay? Sa Supreme Court, in this case, the Supreme Court did not agree with the view of the Court of Appeals, okay, and of the respondent that upon approval of the investing prosecutor's recommendation for the filing of an information against respondent, the period of prescription began to run again. Okay? Sabi ng Supreme Court, it is a well-settled rule. Okay? Na ang once na nag-file ka na ng complaint sa fiscal's office, it will now suspend, it will now toll, it will now interrupt the running of the prescriptive period. So, the proceedings against respondent in this case were not terminated upon the city prosecutor's approval of investigating prosecutor's recommendation that an information be filed with the court. Next one. Who must prosecute criminal action? Sino ang may control sa prosecution? Okay? A criminal action is prosecuted under the direction and control of the public prosecutor. This is the general rule, and it applies to criminal action commenced either by complaint or information. So, ang taong merong control at direksyon ng isang criminal action is yung public prosecutor. Public, okay? Kasi meron tayong tinatawag na private prosecutor. So, ang may control daw is yung public prosecutor. All criminal actions covered by a complaint or information shall be prosecuted under the direct control and supervision of the public prosecutor. So, in case of private prosecutor, the criminal action is still prosecuted under the direct and control of the public prosecutor. Ano ang rationale nito? Okay? Anong rationale? Ano bang purpose or ano ba ang ibig sabihin nito? Ang rationale for the rule na lahat ng criminal actions ay prosecuted under the direct and control of the public prosecutor is that, anong dahilan? Bakit ba siya laging control ng public prosecutor? The answer is because, okay, ang isang criminal offense is an outrage against the sovereignty of the state. So it follows, okay, that a representative of the state through the public prosecutor shall direct and control the prosecution. Okay? Next one. Lagi niyong tandaan, okay, that in case na ang private prosecutor ang mag-a-appear, it will still require, okay, it will still ask permission to the public prosecutor that the private prosecutor will be the one to prosecute the case for the party. Okay? So what are the consequences of the rule that the criminal action is prosecuted under the direct control and supervision of the public prosecutor? Lagi niyong tandaan na ang public prosecutor, okay, has the power to, number one, meron siyang kapangyarihan to determine whether a prima facie case exists. Okay. Number 2, decide which of the conflicting testimonies should be believed free from interference or control of the offended party. Number 3, subject only to right against self-incrimination. Determine which witnesses to present in court. This is in the case of Chua versus Padilla. So, Padillo, GR number 163797, April 24, 2007. So, in this case, okay, the public prosecutor may turn over the actual prosecution of the criminal case to the private prosecutor in the exercise of his discretion, but he may at any time, okay, take over actual conduct of the trial. Ang ibig sabihin lang nito, since, di ba, sabi ko nga sa inyo, merong dalawang prosecutor, public at saka yung private. Okay? Si public, siya ang may direct control and supervision ng prosecution. Pwede ba ang mag-prosecute yung private prosecutor? Pwede. Pero, kukuha pa rin siya ng approval. Okay? Magre-request pa rin siya ng approval from public prosecutor. Okay? Next one. Intervention of the offended party in the prosecution of criminal action. Okay? Ano nga ba ang role ng isang offended party? 'Di ba sabi ko nga sa inyo, sa isang criminal action, okay, people of the Philippines versus Pedro. Si Pedro ang accused. People of the Philippines, okay, that is the offended party, or should I say the prosecution, magpa-prosecute sa'yo. Paano naman yung mga actual, example yung pinatay, kaya yung ninakawan, the offended, kaya yung private party, ano ang role nila? Okay? There is this so-called fundamental principle in criminal law. Okay? Every person criminally liable for a felony is also civilly liable. That is Article 100, okay, of your revised penal code. So, generally, a person convicted of a crime is both criminally and civilly liable. Yung civil liability for a crime includes restitution, reparation of the damage caused, and indemnification for consequential damages. So, ang isang civil liability daw, di ba sabi ko nga sa inyo, Article 100, dalawa yan, yung civil at saka yung criminal liability. Of course, you know your criminal liability, that is imprisonment. Paano yung civil liability? It can be through IRR. Ano yung IRR? Indemnification, restitution, or reparation. So, except when the civil liability is extinguished, the offender shall be obliged to satisfy the civil liability resulting from the crime committed by him, even if he has already served his sentence consisting of deprivation of liberty or other rights, or has not been required to serve the same by reason of amnesty, pardon, commutation of sentence, or any other reason.